Welcome back to our second session on property law and its relationship to environmental law. There is no right to the environment in the U.S. Constitution, nor is there an absolute right to property in the United States Constitution. There is, however, in the United States Constitution, this provision. It's known as the Just Compensation Clause. It allows the government to take property for a public purpose, but when it does so, to pay just compensation to the owner. And the basic idea of it sounds in fairness. After all, when the government takes private property, let's say, to build a road that will benefit everyone, it really wouldn't be fair if the burden, the cost of building that road, were to fall disproportionately on the few landowners, or even the single landowner, whose land was taken. It's a basic concept of fairness. That said, the question is to what extent and under what circumstances the government needs to pay just compensation. The most obvious example is the use of the so-called power of eminent domain. That is when a government, a local government, a state government, even a national government, acquires land outright. It simply goes to court, seizes the land, the term is condemns the land, takes title to it in the government's name, and everyone agrees when that happens, the government will pay just compensation, as determined by the market value of the property. But what about when the government doesn't outright seize land, but adopts rules that directly affect that land and the property owners who reside there? For example, what if a local municipality adopts a noise ordinance to keep peace and quiet in the community, and yet there is one landowner who owns a quarry that requires blasting to dislodge the rock that can be mined? If the noise ordinance prohibits the blasting, the landowner might as well say, "You could have taken my land and had the same effect. If I can't blast, the land is really useless to me." It's as if your regulation took my land. When that occurs, it's known as a regulatory taking, when the effect of the regulation so disrupts private interests in land that it amounts to the same thing as if the government had condemned it. We're going to look at regulatory takings cases today and next session, because frequently when governments adopt regulations under their police powers to protect the environment, they have and in fact are designed to have significant effects on private property interests. And the question is, to what extent that interference may or may not amount to a regulatory taking, requiring payment. Perhaps the most famous case decided in the United States is a case called Penn Central versus New York City. And it involves a very famous landmark, Grand Central Terminal, often known as Grand Central Station, in downtown New York City. Grand Central Station is the point in New York City, in Manhattan, where commuter trains from all the surrounding areas come into the city and connect with the city's famous subway system. It has been for over 100 years the transportation hub that in fact makes New York City and Manhattan really what it is today. At the time this case was brought, it was owned by the Penn Central Railroad. By the way, we're not talking about Penn Station, which is another train station. This is Grand Central Station, right in Midtown Manhattan. What's significant about Grand Central Station is that it had been recognized for its beauty, and in particular, its outside beauty. Millions, tens of millions of visitors a year go to Grand Central Terminal just to see it. Well, it so happens that in the 1960s, the city of New York decided to create a system to protect especially important buildings, landmarks that really characterized Manhattan for what it was and contributed to the beauty of the city. Because there's always real estate development and old buildings are torn down to make up for new ones, the idea was to preserve some of those historic landmarks from destruction. There was a long, complicated process by which different properties would be nominated for and put on the landmark list. There were opportunities for the owners of those properties to go to court, to contest this, to have their say, and so on. But once on the list, you needed permission before you could do anything to seriously affect the architectural and aesthetic qualities, the beauty properties of those buildings. Grand Central Terminal was added to that list. It was a designated historic landmark. And this became a problem when the owners of Grand Central Terminal, the Penn Central Railroad, wanted to build up. They wanted to put a skyscraper on top of what was then a fairly low building, Grand Central Terminal. If you know anything about Midtown Manhattan or great cities in general, you know that some of the most important property rights in big, dense cities are air rights, the rights to build up. And certainly, the Penn Central Railroad had the rights as the owner of Grand Central Terminal to build up, subject to the local zoning ordinances. It didn't mean they could build as high as they wanted, but they had the right to build up. It belonged to no one else, and they wanted to exercise that right, and it would be profitable for them to do so. But the Landmark Commission refused to allow those plans to be taken into effect, because to do so would destroy the beauty of the building. This regulation, designed to protect the public's interest, aesthetic interest in the beauty of New York City, was challenged by Penn Central Railroad as a regulatory takings. It's as if, Penn Central argued, you simply condemned under the power of eminent domain our air rights, but didn't pay us for it. The question was this a regulatory taking for which the city had to pay? In Penn Central Railroad, the Supreme Court first of all concluded no, it was not. But more importantly, created some guideposts to guide future decisions about when governmental regulations to preserve, in this case, the urban environment, do or do not amount to regulatory takings requiring payment. Generally, the court established that for there to be interference, the interference really does have to be substantial interference and really upset the reasonable investment-backed expectations of the landowner, of the property owner. In making this determination, the court concluded that there is no overarching formula that always gives the answer. It's a case-by-case process. And among the things that were relevant here were, number one, the Penn Central Railroad was allowed to continue to use the terminal for its primary use, which was as a transportation hub. Nothing about the prohibition on the air rights did anything to affect the Grand Concourse or the subterranean networks of terminals and railroads that was the central purpose. That was quite important, because after all, the land was acquired for that principal purpose, and nothing in the regulation affected that. And while it's true that virtually all the air rights were taken, in looking at that, the court said we look at the property as a whole, not just the air rights as one element. And looking at the property as a whole, the regulation only affected one aspect. Moreover, the landmark law at the time had a very innovative approach to deal with the air rights. It allowed the owner of land affected by landmark status to transfer the right to build up to other properties nearby. Those are known as transferable development rights. So, for example, even though the effect of landmark status was that the railroad could not build the skyscraper right there atop Grand Central Terminal, the owners had the right, the exclusive right, to build in nearby areas a little bit higher than the surrounding zoning laws allowed. And they could even sell that to somebody else, to transfer it to them. So when you considered the transferable development rights, they're known as TDRs, as well as the fact that the primary purpose of the terminal wasn't affected at all, this was not a case, the court concluded, where the regulation went too far and required payment. And that's the legal test. Does the regulation go too far? In noting that it doesn't here, the court made it very clear that even if a regulation significantly affects market value of the property and reduces it, that does not require payment. In fact, in some instances, regulations that have reduced market value by up to 70% or sometimes even more have been found not to constitute regulatory takings. It's just part of the obligation of living in a society. Sometimes you have to be subject to overarching public interests reflected in these regulations as part of the society in which your property is embedded. And in this case, because the regulation didn't go too far, the government didn't have to pay. The court noted, by the way, that if the government had to pay every time there was any effect, well, that would be the same thing as saying the government really couldn't use its police power at all, because it would be too burdensome to pay for everything. Plus, in fact, that's part of the conditions of owning property. It's subject to the greater good to a point. And in this case, that point wasn't reached. Next time, let's look at one of the more modern statements of the Takings Clause, and one that deals with an environmental value that's especially relevant today. The question of what happens at coastlines in the face of rising sea levels and storms. I'll see you then.